Okay, look, I declare open this hearing of the House of Representatives Standing Committee on Economics for the review of the Australian Competition and Consumer Commission Annual Report 2023. I welcome representatives from the ACCC and look forward to hearing from them about their recent work. I also welcome members of the public and media who may be watching today. The ACCC is Australia's competition regulator and consumer watchdog. It plays a vital role in ensuring a competitive and fair market and protecting consumer rights. The committee is particularly interested to hear from the ACCC in the context of today's cost of living challenges, with widespread community concern about business pricing practices in highly concentrated markets, including supermarkets, banking, and insurance. The ACCC also plays a critical role in ensuring a dynamic economy with high productivity growth. I note that recent committee reports included recommendations for the ACCC. The committee released its report into economic dynamism, competition and business formation in March 2024. Several of the recommendations of the report which pertain to the ACCC have already been implemented, and the committee is looking forward to hearing about the implementation process and potential for further changes. One of the recommendations of the report which has already been actioned is the introduction of new merger laws, which will come into effect from January 2026. The committee is eager to hear how these new powers may be used to fulfil the ACCC's mandate. The committee is also interested in the ACCC's work in relation to the Insurance Council of Australia to develop standardised definitions of key terms in insurance contracts as recommended by this committee in its inquiry into the insurers' responses to the 2022 major floods. The committee also looks forward to hearing from the ACCC on other emerging and ongoing developments, including its new supermarket inquiry, the work of the National Anti-Scam Centre created in 2023 and its long-running digital platform services inquiry. In accordance with the committee's resolution of 9 August 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of the proceedings will be published on the website. I remind members of the media who may be watching of the need to fairly and accurately report the proceedings of the committee. I remind all present that as chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. I now welcome representatives from the Australian Competition and Consumer Commission appearing for today's hearing. Before an opening statement, I would ask for the benefit of Hansard that each of you please state your full names and the capacity in which you appear before the committee.
Thank you very much, Chair, and we're very pleased to be here and to be accountable to this committee and to the Australian public. I'm Gina Cass-Gottlieb, the Chair of the ACCC.
Thank you.
Good morning, Chair. Sarah Proudfoot, Interim CEO of the ACCC.
Thanks, Ms Proudfoot.
Good morning, Tom Leuner, Executive General Manager of Mergers, Exemptions and Digital Division.
Hello, Chair. Rami, Greiss, Executive General Manager of Consumer and Fair Trading.
Good morning, Chair. Nicole Ross, Executive General Manager of the ACCC's Infrastructure Division.
Good morning, Kathie Standen, Executive General Manager, Consumer Data Right at the ACCC.
Good morning, Madeline Richardson, Executive General Manager of Consumer and Product Safety at the ACCC.
Good morning, Chair. Melinda McDonald, Executive General Manager of the Competition Division, ACCC.
Great. Well, thank you. Oh, sorry.
No, I was just going to say I think that is us.
Oh, great. No. Well, thank you for bringing such a strong team that so comprehensively covers the Commission's responsibilities. I remind you that although the committee does not require you to give evidence under oath, the hearings are legal proceedings of the Parliament and warrant the same respect as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. I remind any members or witnesses appearing remotely via video conference or teleconference to mute their microphone unless given the call. I now invite you to make an opening statement if you wish.
Thanks very much, Chair. I will actually note also that Richard Home, who is the head of our Digital Identity Division, is also with us. I'm actually not going to make an opening statement. I'm going to very briefly take the opportunity to record the service of Scott Gregson, who has been our CEO but has been at the ACCC for 29 years, from graduate to CEO. He's to leave us to join ASIC. He has left an indelible mark on the agency. He's appeared before this committee on multiple occasions. He has deep expertise in enforcement and leadership across multiple divisions and always brought a strong commitment to consumer protection, competition and organisational improvement, and a real care for our people and the people we serve. We're deeply grateful for his dedication and leadership. It's a loss for us and a great gain for ASIC. I am pleased to see what an opportunity people have in public service to grow their capacities from grad all the way through to CEO and to move while showing such deep commitment to public service.
No, well, thank you, Chair, for recording that, and I'm sure the committee would echo your thoughts in paying tribute to his long service. So thank you for getting that on the record. So are you happy just to start with questions?
I am, and we are. We felt our last appearance before the committee, many members had many questions, and so we thought we should give you maximum time.
No, thank you. Okay, well, look, I've got a couple of members who have a desire to ask questions earlier rather than later. So what I might do is I'll just ask questions on one topic, and then I'll hand over to the Deputy Chair and a couple of other members, and then I might circle back. But I just wanted to start with mergers. That was one of the major topics that came up in our competition and economic dynamism inquiry. We made some recommendations, and most of those recommendations were reflected in actions taken by the government, and laws have been passed. I'm just interested in whether you'd be in a position to drill down a bit on some of the key changes and how you think they might play out in terms of helping to create a more competitive and dynamic economy.
Thank you, Chair. And indeed, the case for and data supporting merger reform was a key part of our submission to this committee in your inquiry. And the reason it is that the ACCC needs and now has fit-for-purpose law and tools targeted at identifying and preventing anti-competitive mergers. It is so crucial that we can see, assess, and where necessary, prevent anti-competitive mergers. It's not only in a situation where we have significantly increased concentration in many markets across our economy that it is important to protect what we have and to be able to see and thereby protect what we have. But in addition, we are very conscious that acquisitions of small competitors, but who may be vigorous, differentiate on price, differentiate on service, is actually interfering with the promotion of competition, because those can actually, frankly, punch above their weight in terms of the competitive rivalry. And so the ACCC sees this as a most important reform towards our core objective of promoting competition. The key elements are the mandatory notification, because previously we had experience both with major domestic and international transactions that we didn't see them. But in addition, the treatment of serial acquisitions. So there are sectors, including supermarkets, liquor, retailing, cancer, oncology, radiation, for example, where large participants have a practice of multiple smaller acquisitions, and the treatment that is given to serial acquisitions allows us both to aggregate them together over the specified period of 3 years to determine if they meet the thresholds for mandatory notification, but also to assess the competitive impact on the basis of each of the acquisitions in the same relevant industry sector over the past 3 years. It also importantly clarifies that the creation, strengthening and extension of substantial market power is substantial lessening of competition. I also do want to draw attention that the capacity for the Treasurer to specifically, by an instrument, designate sectors that are important to consumers, important to the economy, for which there can be set specific thresholds lower than the economy-wide thresholds. And the Treasurer, in his speech to the Parliament, indicated that supermarkets, liquor and liquor retailing and oncology, radiation oncology were candidates for this. So that it puts in place a capacity for the ACCC to do what we are mandated to do, which is to protect and promote competition. In addition, I just would like to give the committee an update on our preparation, because we are very actively engaged in preparation for this change. We know it will be a significant change for Australian businesses, as it is for the ACCC and as it is for the protection for the community. And it's important to emphasise that these reforms also, we believe, will assist the economy in its dynamism by establishing faster, targeted, more transparent and certain merger regime, so that those transactions which have the risk of anti-competitive impact we will focus on and we will target our resources to. But those many mergers which will assist commercial regeneration, funding of new investment, enabling growth to better serve a market, will have much more certainty, because there will be transparency about our decision-making, which has not been the case to date in an informal regime. There are binding statutory timeframes, and we expect about 80% of notified transactions will be decided in the first 15 to 20 business days, and all of that will rely upon a risk-based process. So we consider the regime strikes that right balance between focusing and being able to prevent anti-competitive transactions which have that risk, but otherwise minimising regulatory burden for non-contentious acquisitions. We are well advanced. We issued a statement of goals of implementation in October last year. We are well advanced and will be issuing draft consultation on our process, on our analytical approach, and on transition arrangements by the end of this first quarter. We will then give the opportunity for the community, large business, small business, to comment, but it means that by the 1st of July, when there can be the first voluntary notifications, everyone will be well informed about how we're going to approach this. And the final point I just briefly wanted to refer to, Chair, and for all members of the committee, because many of your recommendations also address the importance, including for the ACCC, to increase our use of and application of data and data analysis, and this will be an important part of this merger process. We have expressed our commitment that we will be heavily informed and benefited by the collection of data relating to the transactions, the aggregation of that data covering the sectors that we are seeing transactions in. We have obligations to report that annually. We have, in addition, we are working in a co-lead with Treasury on a whole of economy project to look at localised industry concentration using both blade data and pleader data, so ABS data sets. But in addition, our merger database, which will capture data relating to transactions, there will be aspects, of course, that are confidential and we'll protect them, but we will build an aggregated data set which will be valuable not only for our work, but for the review that is proposed by Treasury the first year on thresholds and on the third year on the effectiveness of the regime, but we'll also be able to support other policy considerations. And many of the aspects in this committee's report looked at the importance of having better and more valuable data sources to inform these competition questions.
No, thanks very much for that. Well, look, I might circle back later on to some of those issues, but I'm conscious that a few people have time constraints, so I might hand over now to Mr. Wallahan.
Thank you, Chair, and thank you Chair of the ACCC. I just have two questions. The first is on merger reform. Got an election coming up, and through the looking glass, we may have a minority government, and there may be terms and issues that were settled or revisited. So from your perspective, your position on the reversal of onus wasn't adopted. So my question is, do you feel that merger reform is done, or is there more to look at?
We are satisfied that this is the right package, and it was a package that you were right. We had commenced with the reversal of onus, but we are comfortable that as administrative decision maker, with the ability to obtain the information that we require to make properly informed decisions, that we embrace. So I was going to say settle with, but I will say embrace that in order to not approve, we need to have determined that we consider that a substantial lessening of competition is likely.
Thank you, Chair. My second question just needs a little bit of context, if I may. I represent a metropolitan seat in Melbourne. It's the outer suburbs around Warrandyte, Doncaster, Templestowe. And my question relates to the relationship between the banks and Australia Post. You would have seen recently that 3 of the 4 major banks have signed fresh agreements with Australia Post to offer in-person banking services. And then separately, the federal government has struck a deal with the 4 banks to keep regional branches open until at least mid-2027. I just want to get your thoughts and perspective on how this impacts competition, particularly given that the majority of Australians still are also in metropolitan areas. Is that relationship and that carving out of regional area, do you think that may see offsets in those sort of services being offered in metropolitan markets? And so I don't really have a question. I just want to know, are those 2 separate changes and agreements something that may have competition issues for you to consider?
As we understand the way the banks bank at post agreements have been intended to operate, and the recent announcement, they're particularly focused in regional areas because there has been an increasing removal by the banks of their in-person presence in regional and particularly remote, where they may have never had such an active engagement. In this sense, we recognise that the bank at post solution is an ability for people in those regions to have personal service. In the past, the ACCC has also authorised collective action by banks to have ATMs available in regional and remote areas where they were not going to individually do so. So in a sense, we would see this as sitting as a recognition that there needs to be a particular treatment to meet that need. In part, one of the questions you're raising is that might there be some sort of cross-subsidy occurring? Those questions, so in part, you will be aware that in the ANZ Suncorp matter, the ACCC felt there were some elements of coordination and a position of dominance of the majors across various banking sectors, and that showed coordinated behaviour. There are some smaller and regional banks who provide competition, but the ACCC did say, of course, the tribunal was satisfied that that transaction should be authorised. The ACCC did say we watch closely the question of competition in the banking sector. So it is an area that we look to carefully. The other regulatory role we have is we do review on a price notification basis the charges of Australia Post for the purposes of the regulated stamp charges. We have proposed to the relevant department and to government that there are very important services that Australia Post is providing, both parcel delivery services, which are not addressed in that review, but also there may indeed here be increasing banking in regional area services. We've proposed there should be a fit-for-purpose proper power to look across the whole cost allocation of Australia Post. Now, that is an initial proposal. It would give more scrutiny of the question you're raising, but I would not say that we prima facie are aware of a competition problem at this time, but we don't fully scrutinise the question either.
Thank you, Chair, and back to you, Chair.
Thanks, Mr. Wallahan. I'll hand over to Ms. Spender.
Thank you very much for your time today. I had a few questions at a sector-by-sector level to start with. Particularly want to start with airports. It's a key area and of concern for the community. So airports, and flights more broadly. Concern about increasing in prices of flights and levels of services. As in August, the government went to tender for an airport slot manager, which the ACCC states would have a small impact on competition. And I just want to check in with you to see whether you're satisfied that the process for securing a slot manager will be suitably independent to have an influence on competition.
We do consider that these reforms are critical, as you are reflecting, Spender. The rules that had sat for quite some time in relation to slot management had advantaged the incumbents, particularly Qantas and also Virgin, and were certainly one of the aspects that over quite a substantial period Rex had pointed to as being problematic for them to expand into the higher volume and more profitable routes. The reforms that have been announced we think are very important. We do consider, on what we have seen of the process that has been proposed, that it meets the standards across government you would expect to see in terms of integrity and independence. The critical point is to move from the situation where currently there's a representative of each of the airlines making these decisions, which manifestly does not have the required independence and, in fact, poses conflicts.
And I want to ask a slightly more broader question. With these sort of changes, and as you said, you believe that will be critical to competition. Are there other changes within the sort of airline or airport slot management piece that you think are critical to sort of bringing back to competition within the airline sector?
The points that we have identified related to changes in the rules, actually so that they would be more in line with the worldwide approaches, to change the definition of who is a new entrant, to not preference existing incumbent holders of slots whenever they wish to make a change or there is a new slot. So it will be very important to see that each of those changes are put in place in order to, so it's not solely the slot manager making independent decisions, but elements in the rules which were tailored and specific here to the management of Sydney Airport, but not in line with worldwide rules that do need to change.
Okay, and in terms of the timing of this, I mean, are you satisfied with the timing in this? Because obviously there've been discussion around airport slots for a number of years, certainly since I've been in Parliament. But I understand that this, there were reviews before there. What do we need to do to actually see this happen in relation to some of those other critical parts?
The ACCC and their industry, and also there was a review, have for a number of years proposed change. So we're keen to see this change happen in soon as possible in a practical sense. I can also see the head of our infrastructure division has come on screen, and so I'll just see if Nicole would like to add something here.
Ms. Spenter, you may already be aware, but my understanding is that on the 9th of October, the government did introduce the Sydney Airport Demand Management Amendment Bill, and that's now passed both houses of Parliament, so it is progressing.
My question really goes to, do you feel that this is enough, and what else is outstanding, really? I think that's really the question I'm going to.
I think it is progressing, and we're very much welcome the reform and looking forward to seeing how it's implemented.
Sure. Okay, great. I wanted to talk, this is a specific issue that actually one of my colleagues on the crossbench raised yesterday in the House, which was about petrol prices in Mudgee. I know it's a bit particular, but it goes to a broader question in terms of petrol competition. So the concern that was raised by the member for Clare was that petrol prices in Mudgee around 20 to 30 cents higher than other parts of the region. I know that he has raised this with the ACCC and received a response, I think, in August last year. My understanding is that there are 3 petrol stations literally within walking distance, BHP, Shell and Ampol. So there is that competition, but there seems to be a significant higher price, even compared to other parts of the regional community that he represents. This could be a question on notice, but I guess the question is, how do we, this has been raised for around 6 months, how do we, when there are those specific issues in particular areas, how do we get on top of them or to address them for those pieces?
I recall actually that question, and I recall our answer. We did look at the immediate surrounding area, but also other areas that in New South Wales that had some similarity in terms of either distance from imports, from where the fuel was being imported, and also the extent of competition. And why were we looking at it? Perhaps I should first say it's important. We do monitor pricing. We monitor pricing both in the capital cities and overall, I think, and Nicole can correct me, I think 190 locations in total. And we do also put recommendations to consumers relating to using fuel price apps, because particularly in metropolitan areas and larger regional areas, it can be up to 40 cents and in some cases 50 cents difference for a short drive. However, there are some regional areas where there are few competitors. And some of this is the playing out of where you do not have enough rivalry to keep the benefits of lower prices and price restraint. We do ask ourselves, and one of the reasons we tested this against other similar regional areas was to say, might there be some coordination happening which might be a competition problem, in order to ask, should we look at that as as potential anti-competitive conduct? But we did not have evidence of that and looking at the comparison. So we have 3 roles here. We look closely at questions of accuracy to consumers and not misleading comments in relation to fuel price quality or price. And we have recently taken action against Mobil in relation to pricing in very North Queensland, highly regional areas, which described to the product as premium additised product, and it did not actually have those additives. So we are watching closely. We're doing so in a monitoring sense. We're doing so in a consumer protection sense. And if there were to be, and if your colleague had a view that actually there does appear to be something more concerning in a conduct point of view, we would want to hear from him or her.
Okay. Well, I'll refer that back then to the member for Clare, because I think, from my understanding, that is his concern, that it is a significant issue, and it's surprising because there is the semblance of competition, but there is a significant high price. So that is the concern that he's raised. I wanted to jump now to supermarkets. I know this is an area of real interest to many. The recent E61 research highlighted some supply side issues around land use policies as a barrier for entry for competitors, with other research describing it as complex, excessively prescriptive, and often anti-competitive. Do you see that there's that sort of this area around land banking policies is an underutilised policy tool for increasing competition? And have you been able to find any evidence of land banking? It's certainly one that comes up sometimes in discussion with the major chains.
We have, in the process of this inquiry, made inquiries and obtained information, and we did in the interim report note the numbers that were held by each of Woolworths and Coles. In our final report, we will also identify further, and that final report is due to be provided to government on the 28th of February, so very soon. If, and this is still, it's important to note that I'm not indicating where the report will go because it's not concluded. If we were to see acquisition of properties that are being held either with a purpose to impede the entry of others or with the effect of impeding the entry of others, that would be a competition question. And it would be a question for us to consider under our powers in relation to anti-competitive conduct. One other aspect we think is important is the agreement that was signed between state, territory and the Commonwealth Treasurers at the end of last year in a refreshing of the national competition policy. We do think at both a council level and a state and territory level, it is important to open up the greater opportunity for the development of supermarkets and, frankly, other commercial developments in areas which at the moment have either prohibitions or which have really very long time frames and onerous processes, because it certainly does indicate a barrier for a new entrant, and including for smaller participants who want to expand. The ACCC did, after 2008, and what we found in that first grocery inquiry, identify areas of restrictive provisions in the leases by Woolworths and Coles, which prevented a comparable supermarket being in the shopping centres in which they were operating. And that investigation about alleged anti-competitive conduct was resolved on a basis that they removed those clauses and didn't enforce them. And after that intervention, Aldi was able to expand to the size that it is today, and it was having trouble doing so. So that is reinforcing your comment that this is a very important area of focus.
Okay. Lastly, my question, this is sort of a final question, which is more broadly about the sort of ACCC sort of performance reporting and performance indicators. Obviously, the ACCC is absolutely critical as a as an institution, for small and large businesses to protect competition. And one of the some feedback I get from different businesses not just about the ACCC, but around many sort of regulators, is that sort of time frames of regulators don't necessarily meet commercial reality. That they may wait for sort of feedback from regulators or feedback from government institutions that just doesn't fit with the timelines of them, even in some cases being able to maintain themselves as a business, if it's a very if it's a very serious issue, or be able to certainly make timely decisions in relation to their own sort of investments or other or dealing with competition issues that they see as egregious. One of those. So I saw, just looking at the performance measures. I can see for 2022-23, I'm just looking at a screen, I can see that around 12 of the 21 performance measures were met. And one that particularly I sort of stood out for me was that only 46% of draft determinations were released within 4 months versus a target of around 80%. So I just want to ask about that, about progress towards these SLAs, and how do we provide businesses timeliness, or how do you think about timeliness of determinations and responsiveness to businesses as in terms of your prioritisation of your work?
Thank you. So I'll separate that into different areas of the work that we're doing, but in principle, we take very seriously having a proportionate and effective engagement. And also improving our performance. And we're very frank in putting our performance there, and we do look to improve. And our new merger powers and the new merger regime will be a very important change. We are subject to strict timeframes. We are absolutely deeply aware that the effectiveness and streamlining of our implementation of this reform is critical to its success. And it is why we have been so frank about our objective that 80% will be concluded within the 15 to 20 business days from being lodged, which is the shortest time frame we're able to do it under the legislative framework. So we have a very specific set of objectives there in relation to the new merger regime. When we look more broadly at determinations in conduct matters, so for instance, parties coming together who are otherwise competitors but want to agree to work together, we do take into account always where matters are urgent, and we have given interim authorisations, for example, where there are urgent requirements, and we look at it carefully and we do so. We are very conscious with those matters that we are actually exempting participants from the Act when they're engaging in conduct which otherwise would be prohibited. And if we do not get information early from them, I need to move a bit more actively, if we do not get information sufficiently promptly, then it can take more time. And we also wait to get third parties have the capacity where we are exercising that jurisdiction to put submissions on as to whether or not. So there are other factors that are important and that are in some ways outside our control because we know we must be fully informed. So that is an important aspect. And if we look, for instance, at enforcement matters, those matters we need to be very careful to investigate fully. Frequently, parties take a lot of time and aren't necessarily cooperative with an investigation. And because we are making important decisions whether what mode of intervention to take to protect competition or protect consumers, we need to take the time to do them properly. I can see that Tom Leuner, who is the head of our mergers and exemptions division, is on screen. Tom, did you want to add something?
Oh, thank you, Chair. I just wanted to add that with that KPI, we did miss it by some margin, but I think it was a particular year where we just had a lot of controversial conduct authorisations and often quite late issues being raised by third parties, which necessitated pushing out the draft decision beyond the 4 months. I don't think it sort of reflects a change in approach or anything like that. As the chair mentioned, often we grant interim authorisation, even in a matter of days or weeks, where there's a real commercial urgency behind the matter.
Okay. I guess my question is, with any sort of raft of and range of performance indicators, where are your priorities then? You're meeting some, you're not meeting some, and it's hard to do everything at once. What do you see as the top priorities for this year in terms of trying to meet SLAs? Which are the ones that you think are most critical to providing service to and competition effectively to the Australian landscape?
Very high in the priorities will be the new merger regime, and that is to enable the ACCC to do it, minimising regulatory burden in the vast majority of notifications, and also for the business community to build knowledge, certainty and confidence in the program. And the small business community was very supportive of the reform. And there will be quite a change in the service that is given, because we are obliged also to put our decisions, to give written notice and explanation of our decisions within 24 hours. So not only will the register show what we are considering, and it will enable a much broader of the business community to be informed about what we're doing and to participate in the process. And that I do consider that not only is timeliness, but transparency and guidance and certainty are a very important part of the service that we're giving. And as examples of where, in relation not only to greenwashing, but to our guidance on collaboration by business to achieve net zero targets and greater sustainability, we put each of that draft guidance out early. In relation to the collaborations, we got a lot of response, actually, including members of the community and businesses saying that they wanted to see a broader ESG definition, and we considered this carefully and we did it. So I would prioritise mergers, timeliness and good consultation so that the business community really understands the guidance that we are working to, that we get real input in relation to the guidance so we can hear back where we're falling short. We are also commencing from the first meeting will be early in March, and ACCC Performance Consultative Committee, which has representatives of small business. It has representatives of consumers, representatives of large business, academics, advisors. And the topic expressly is to look at our performance and to assess, for us to raise aspects where we are looking for feedback, but also for the participants to give us feedback as well. So we're moving to a face-to-face process for that. We have had a survey biannually, but we're now going to move to it. And we have appointed and we are having an independent chair. So I'm not chairing it. We're having an independent chair in order to ensure that the participants have confidence that they can raise what they want to raise. And so that is another aspect in how we are looking at moving outside our bubble and really receiving and taking into account the feedback that we get.
Okay. Well, thank you. And given that this is the last hearing, I think, of this committee before the election, thank you very much also for all the engagement that it's been as a member of the committee. I really appreciate it as well. Thank you.
It's a pleasure. Thank you.
Thanks, Ms. Bender. I'll hand over to Mr. Ray.
Thank you, Chair Molino, and good morning, Chair Cass-Gottlieb. Thank you to you and to all of your team for your attendance and considered responses. I want to pick up a theme that Ms. Spender started with, but I want to drill into it a little bit deeper and a little bit more passionately because it is directly relevant to me and my community, and perhaps to give it a headline, it's the Melton fuel pricing issue.
Yes.
And you may have some advisors who can grab stuff for you while I kind of run through it at a high level. So Melton is a township in my community in Hawke on the outer western suburbs of Melbourne. It is one of the original satellite cities of Melbourne under the sort of 1960s and 70s era town planning structures in Victoria. It's a geographically isolated market, although it is part of metropolitan Melbourne, both structurally, culturally, and as far as the ABS is concerned, it is absolutely a part of metropolitan Melbourne, but it is geographically isolated just in terms of transportation. It's got lower household income demography than most parts of Australia, and as I said, significant structural transportation issues. It's also the fastest growing part of Australia. There's a number of fuel stations, some that have been there for a very long time and some that are more recent across the township, but there are what I consider absolutely demonstrable patterns of both the local fuel prices in Melton being materially higher than surrounding townships, surrounding suburbs, as well as the statewide and the national prices. And sometimes that can be by as much as 50 to 80 cents per litre. So this is absolutely material in terms of the delta, if you like. And then again, I consider this demonstrable in terms of the price adjustment behaviour that happens to maintain that localised discrepancy. There appears in both the timing and the outcome of those price adjustments to be remarkably consistent behaviour across the local providers. So in short, Melton, already facing a range of structural disadvantage issues, is also facing significantly higher fuel prices than anywhere else in Australia, and the pricing behaviour appears at face value to suggest some level of cooperation or collusion between the local retailers. There have been dozens or perhaps even hundreds of complaints to the ACCC from my community around that, and I've engaged with Minister Lee on the issue over the last few years. So my question in the context of all of that is, ideally specifically, or at worst generally, what are the options that the ACCC can offer in terms of supporting my community to address this issue? Is there something around a sort of a case study investigation that could occur? I've obviously absorbed all of the information, the more generalised information the ACCC provides around regional fuel pricing discrepancies and whatnot. But this is a metropolitan area. Both closer in, the suburb closer in and the suburb further out, both have, as I said, demonstrably and materially lower fuel prices. So it doesn't appear to be a transportation issue. It doesn't appear to be driven by the size of the market. It's the fastest growing area in Australia. So this is a very specific set of issues, and my community very much needs the support of the ACCC to try and get it resolved.
Let me start with the data, because my team had yesterday, not for this morning, but yesterday, given me Melton fuel prices.
Wonderful. What a great team.
They are a great team, and they had indicated to me that they understood you would be concerned about it. So what those prices showed, that the highest prices, and that appears to be quite a number of the sites, at close to $2, are certainly higher than the average Melbourne price at $1.83. There was one lowest price at $1.69, but it so there seems to be at least one petrol station, and perhaps some others that are differentiating. However, and it appears to be the sort of inbound one on the highway, so perhaps it's responding to highway competition rather than so much for the local residents.
For what it's worth, thank you. For what it's worth, it's also part of that geographic isolation. It is separated from the township.
Yes, thank you. There are a number of points that are relevant in our powers. So one is the consideration that we give through petrol monitoring, and we do consider that there is a gap in Victoria because there isn't a fuel price transparency scheme. We do, you are certainly identifying here your own report, and you know it intimately because it's your constituency. But we certainly see that one of the benefits of fuel transparency schemes are both the ability for there to be choice for the motorist, but in addition that it has that benefit of more sunlight because you do actually, in a mandatory sense, see, and we would then better be able to see and have confidence that you can see who's moving up and down when. So that we think would be valuable. Secondly, we can, in a monitoring role, look more closely in a study sense. We do need to carefully think about where we apply that, but that is one option. The other, which when you are describing the price adjustment behaviour, is the question of whether there are concerted practices happening here, which would be short of coordination, but a sharing of information that would mean there is less competitive and commercial tension, and which has an effect of substantially lessening of competition. Those sorts of aspects that ACCC did a number of years ago commence a case actually looking at pricing across Melbourne in relation to the question about whether the sharing of data by petrol retailers through informed sources was enabling a capacity for coordination. The ACCC did ultimately settle that at the time on the basis of there being full transparency and availability for consumers to see the data on a sunlight basis. If there were to be evidence that there is actually coordination, we would look at that very closely. We would investigate, and we would consider that real consumer detriment and competition detriment, which we would then look at in an enforcement sense. Apart from that informed sources action, there had previously been actions that ACCC had taken in relation to movements in pricing and where they appeared to have elements of contemporaneity and at times previous chairs called it synchronised swimming. The courts did pause before, in a number of those cases, actually finding a contravention. To the extent that in the absence of very clear evidence of an agreement relating to the price setting, they felt that there hadn't been sufficient evidence and that there may just be factors such as an increase in terminal gate price or other factors which meant that most of the participants move in a similar timing. So if we look at our toolbox, we've got monitoring, we've got investigation as to whether there's anti-competitive behaviour. There is complexity, though, in the way in which, in terms of that, they are complex cases from an enforcement perspective.
Thank you, and I appreciate that, and that these challenges sort of have multiple layers to them, with the enforcement piece kind of, I guess, being at the end of it. And there's of course I guess the statistical demonstrability of the anomaly,
Yes.
and then once you've identified that, there's a body of work to be done to understand what level of cooperation is going on there. My question for you, and I'm happy for you to take this on notice, is the ACCC in a position to as I said, do a specific Melton Township-based case study or investigation, beginning at obviously using the longitudinal data to prove the supposition that there is a pricing anomaly occurring, and then obviously taking it from there, depending on what the findings are. Is that within the scope of the ACCC, and are you guys in a position to be able to help my community with that?
My understanding would be it would be within the scope of the direction that we have. I can see that Nicole has come on screen, and so if there are points you would like to add.
Not on that point, thank you, Chair. I would note that it is a resourcing cost for the ACCC and something we would need to balance against our existing priorities. The other thing I was wanting to note is there have been a range of announcements around increased or a change to price transparency requirements by the Victorian Government. They're obviously a matter for the Victorian Government, but we do welcome greater fuel price transparency and are looking to understand the detail of that and the impact on consumers in Victoria, including Melton.
Thank you. Well, as I said, perhaps you would.
In view of the questions raised, what we will do is in our relevant committee, when we are looking at the priorities for the monitoring going forward, look at this question.
Thank you, Chair. I'm very grateful for that attention, and offer obviously myself in any way that I can be of assistance in terms of furthering that consideration and helping the ACCC to help our community. So thank you. I'll move on. I want to touch briefly on some of the supermarket pricing irregularities and the what I consider to be very good work that you and your team have done in that space, acknowledging that there are legal proceedings afoot, and I don't want to prejudice any of those sort of live matters that you will have a mind to be rightfully protective of. Is there any update that you can provide us in terms of that publicised work that the ACCC have conducted in relation to supermarket pricing irregularities?
So your caution there in terms of the legal proceedings is important, and we are moving through the preliminary case management elements in relation to that. And as you are aware, we have alleged that there was a misleading representation in terms of the discounts that were represented in terms of the comparison of the prior price and then the discounted price. We will, in our supermarket inquiry final report, which is separate and based upon separate investigations, more broadly look at a range of pricing questions, both as to discounts, as to unit pricing, as to the confusion for consumers with multiple different levels of promotions and pricing occurring. And we are taking into account the concerns that a wide range of consumers and consumer representatives have raised in relation to their concerns as to pricing, as to value, and the even greater significance of that in the current cost of living circumstances.
A couple of related quick fire questions off the back of that, because some of it you've actually perhaps will refer me back to that pending report. But I guess I'm interested in prospectively what can be done to avoid price gouging of consumers, in a duopolistic or oligarchic supermarket sector. Like, what are the prospective policy and enforcement options that are available? Do you think the ACCC has the necessary powers and resources to protect consumers from this type of unscrupulous behaviour moving forward? And perhaps just to throw it out there, one of the possibilities that has been raised by members in my community is the idea of having a pricing commissioner, to which I respond, we have a wonderful pricing commissioner in the ACCC. So I guess, in that tone, I'm just interested in what you see, not with specific reference to those legal matters and unfolding pieces which are of sensitivity, but what you see the kind of the prospective dynamics are around protecting consumers from this type of behaviour.
So it's important to differentiate. We have important powers, as the two cases demonstrate, in terms of misleading and deceptive conduct in pricing practices. And we are looking at that not only in the supermarket sector, more broadly in the retail sector. And an example is surcharges and poor disclosure of add-on costs, which many consumers also are complaining about. What we do not have is a price-setting role. And while the Professor Fell's report on behalf of the ACTU did recommend a new price commissioner role, the ACCC does not have that role. And provided parties are not being misleading and deceptive in their price representations or misleading and deceptive in the quality and other product claims they're making, and also are not engaging in predatory price, which has anti-competitive effects, then we do not have power over it. We are very conscious that the government has recommended a range of changes, including in relation, for instance, to unit pricing, and has also given the ACCC funding to ensure that we are very closely monitoring pricing practices from a misleading and deceptive conduct perspective, and also in relation to the additions to remedies and sanctions can be taken on unit pricing, all of which helps an ability to best compare and get value for consumers. But there are quite complex questions that would arise for a pricing commissioner if there were to be a government decision, parliamentary decision to do so, including there are, of course, multiple products, multiple categories, multiple cost inputs, and therefore whether you would consider that in terms of essential products and not all products, there are many difficult questions there. We have a very important capacity to protect consumers, to ensure that representations deliver value for the expenditure from the family budget in accordance with the pricing claims, but it would need some very careful consideration. We would consider, which this committee in the future and others may want to think about, whether to introduce a new pricing commissioner control in that way.
Thank you, Chair, and thank you again to you and your team for all of your engagement over this period. Thank you.
It's our pleasure. You're on mute, Chair.
Thank you, Chair. I'll hand over to, thanks, Mr. Ray, and I'll hand over to Mr. Luxale.
Thanks, Chair. Chair, I've got a few questions on the ACCC submission to the RBA inquiry on payments and surcharging, if that's okay.
Yes.
Thank you for writing a submission. I think it's really important that your views are considered by the RBA, just going to some of your comments in there, you mentioned that most reports that are made to you, and I do note that there's quite a few reports in the last 18 months, they're concerning alleged excessive surcharging, but you do note many consumers lack access to cost data to verify whether a surcharge is excessive. So when someone makes a complaint, what is the process that the ACCC goes through to verify that complaint?
So we have a process of review in order to look at complaints that are referred, and we look at the impact that that conduct is having. There is an obligation on the acquiring bank for each merchant to provide the merchant with the costs of acquisition, basically the costs of service to them for the purposes of the credit card, debit card transactions. At times, and we did indicate this in our submission, so what we know is that consumers look to the estimates and the range that the Reserve Bank has put on its website of what the costs will be. And they are only estimates, and there is quite a wide range of those costs. Roughly what the ACCC is aware of and has put in the submission, larger merchants are in a better position to achieve lower cost services from their banking provider. And so at times what we find is actually consumers believe it's overcharged, but actually the costs were reflective of the charge. That does not mean that's always the case, but quite often it is the case. What we do see, and as we've put in the submission, Australia, and we think this is a significant benefit for Australia compared to what each of us would have experienced when you're in the US or you're in Europe or the UK, where there are multiple other fees and charges that are included on top of the represented price. We largely have a single price, a unified price approach. These surcharges are an exception to it. And for instance, the government made that decision quite some time ago when introducing the GST, that it should be a price inclusive of GST. So consumers will not be confused. The price that was advertised or up on the board at the coffee shop is the price you're actually going to pay. Whereas actually now, then there can be quite often poor disclosure. And so we those sorts of aspects we wanted to draw out in the submission, that the current regulatory framing is actually in part confusing consumers. And we have recently received from the government funds to take more compliance and enforcement action. We are carefully working on that because we have taken action in relation to overcharging where it was, for instance, we large ticketing supply companies where it were large companies. It is difficult when we see much of this behaviour is large number of very small merchants. And so we are looking at an education campaign and a compliance campaign and in effect warning process in order to make small and medium-sized merchants aware of their obligations here. The head of our Consumer and Fair Trading Division has come on screen, so I will, Mr. Greiss, Rami Greiss, I'll give him an opportunity to also add there.
Thank you, Ms. Gottlieb. I just want to draw out one point that was raised, and that is it appears to us consumers are particularly concerned and upset when they do complain more about the lack of disclosure or equally as much about the lack of disclosure at point of sale as they are about having add-on costs that they feel are unfair. So in terms of that compliance and education, and ultimately enforcement piece will be tackling both of those elements.
Right. So I might just maybe rephrase my question because I'm still not clear of what the process is. So if someone makes a complaint, they're at a small business, and someone makes a complaint of the 2,500, just pick one. What happens with it when it gets sent to the ACCC?
So we've got a process by which we triage all complaints, and those complaints are assessed against our priorities, and then are applied to either, if it's in an area such as this, which is a priority, it would be applied to either a compliance or an enforcement perspective. There will be a investigation, most likely, of the circumstances of the complaint, and it'll then be put onto a track as appropriate.
Okay. And do you investigate all the complaints?
Well, I mean, it's worth bearing in mind we receive at least 100,000 complaints a year, so there has to be a triaging process. But currently, because surcharging is an important issue for us, we would look into each and every complaint that we thought prima facie could potentially breach the Act. Not all of them do. Often we hear that people are upset that a surcharge is added on to the purchase, and that's understandable. However, it doesn't necessarily disclose a breach. So we do assess every single one of them because they are in an important area for our policy setting.
Okay. Do you think that you did highlight transparency of costs to the consumer? Do you think that lack of transparency, I guess, is stopping consumers understanding whether or not they're being excessively surcharged or not? Like how are we meant to know whether? Yeah.
It is certainly one of the factors. Go ahead, Rami.
Yes, I was just going to say the same thing. It is indeed an important issue, because if you're not aware that you're going to be charged and it's not disclosed to you clearly, it's very hard to make an assessment, firstly, whether you want to make the purchase, but also whether those charges look reasonable. So the two do go hand in hand, and as Ms. Cass-Gottlieb said, this skews towards smaller businesses and micro businesses in a lot of cases, and so there is going to be a necessary element of education and compliance messaging, so they understand their obligations to consumers in this process, and also what their obligations and rights are under the law. Once we undertake that exercise, we'll then look for whether there's non-compliance and take appropriate action following that.
One of the issues identified by the RBA in their issues paper is the blended merchant pricing. You're aware of that term?
We are.
Okay, great. So, and this is all public data. Costs associated with debit cards are significantly lower than costs associated with credit cards, both the ones charged out to consumers, but what obviously to small businesses, and businesses. But what happens with blended rates is that you get charged this uniform price. So, I guess I want to understand from you as the organisation, the entity charged with enforcing excessive charges, how are blended prices not considered excessive charging when debit costs are low to the payment provider, right, at 0.2 or 0.3 or 0.4%. So the payment provider, that's what they get charged. But the small business gets charged 1.6% as a blended price. and then obviously the small business passes on 1.6% when it's publicly known knowledge that debit cards charges cost less. Have you had that proposition tested, or is that something that you've considered before, that blended pricing is excessive pricing?
So there have been, and a number of them are public submissions to the Reserve Bank review relating to these questions, but just looking at it separately, we have also had matters raised with us relating to this. There is a complexity here in the current regulation because the obligation not to charge higher than the costs sits at the merchant under the law. It does not sit in the payment service providers who are giving that service to the merchant and who are receiving services themselves up the chain, either from banks or from schemes.
So if a small business complains about being overcharged for debit, you can't investigate that?
So, correct. Actually, we can't, because there is not a price that obligation to only charge a cost reflective price, which, Mr. Laxal, you're really asking us, and I understand that question. That obligation does not apply to the payment service providers currently under the law. The prohibition currently that was put in the law previously by the previous government that the ACCC enforces applies to the merchant, does not apply to other participants in the services chain.
Do you see the issue here, though? Like when debit costs are so low but they're being charged much higher, like is this the nexus of the problem here?
It is an important part of the problem. And one of the reasons in our submission we wanted to draw attention to these questions is there's a possibility that if, for instance, there were to be a prohibition of charging any surcharge by a merchant for a debit transaction, but not a credit transaction. So say it only applied to a debit transaction, but that prohibition does not apply to other participants in the chain, the merchants would be in small merchants particularly, would be in a very precarious position because they would continue to be charged a blended rate fee.
So you've never, just to clarify, you've never been able to undertake an investigation into payment providers like banks or those third-party ones in regards to the costs that they charge to businesses?
Unless they were being misleading or deceptive, which has not been raised, or it was suggested there was some anti-competitive element in the conduct in setting it. It is not within our powers, actually. There are elements of regulation by the Reserve Bank of levels of fees, but they are generally sitting in the credit card. And sorry, I've just got to get the light back on in here. In the credit card and debit cards, and in these intermediary payment service providers, which is actually an important point about the importance of the proposed amendments that are in the bill for the Payment Systems Regulation Act, because they expand the definition of payments providers to those who provide services in relation to it. So there is already, it has just been because of the backlog of passage of legislation, but there are amendments proposed there that would expand the jurisdiction, and we think very important, expand the jurisdiction of regulation, but currently that is not the case at this time.
I just popped on your website and had a look at your media releases for enforcement of this stuff, and the last one I could see was in 2021 for Nine Entertainment. You did again refer to that number of 2,500 since January 23 to June 24. Is that accurate? That last enforcement you undertook ended in 2021. Has there been any more recent than that?
I can confirm that's right. There has not been any since then.
Why is that?
But there have been investigations, Rami, and investigations do prompt awareness of compliance. Whenever a business is investigated, they become much more focused. So there has been activity, but largely that has been in the context that most larger businesses are compliant, which has also been the observation that it is coming through in other reviews. And so we are always looking that our enforcement actions are proportionate to the size of business, proportionate to the impact, which is why we are framing this new program very specifically in a compliance and education framing for the very small and micro businesses.
Is the fact that the payments, I mean, how many of your investigations and compliance is just simply the business not understanding what their costs are? Like, do you have to make those determinations between complex, like it being deliberate and known versus giving a bit of leeway for a misunderstanding? Does that happen often?
So one part I'll just answer in principle, and then we'll allow Mr. Greiss to supplement. One of the key elements in proportionality that we look to is both size of business, its knowledge, how intentional is conduct. So each of those are important parts in when we determine whether to take action, what type of action, and if we are seeking redress, what is appropriate redress. And it is all quite carefully also explained actually on our website how seriously we take that those questions of proportionality. But Rami, would you like to add something as well?
Yeah, that's correct. And I'll go back to the point I made earlier, which is while we do receive complaints, many don't bear any contravention under the Act or likely contravention. So, as I say, people are upset about surcharging. We see non-disclosure issues, and often, so to pick up the point about proportionality, we will write or engage with the trader because they are usually small and unsophisticated. And I think it's those observations that have led us to the view that a compliance and education first step is important, so that businesses do understand what they do need to do, not just from charging the right surcharge, the correct surcharge, but also in terms of disclosure and transparency.
Okay. So in October, you were given $2.1 million from the government to enhance enforcement efforts. How have you used that money? Is that just more compliance officers? How have you used it?
It's going to be a combination of staff that are able to engage directly with business through a media campaign, an awareness campaign, and potentially guidelines. So there's that component of the work. There will be an outreach element with respect to the relevant peak bodies, of course, and other media channels. And then the complementary piece will be enforcement resources to then ensure that businesses are doing the right thing after the initial campaign. So it's both staff and the associated costs with the campaign itself.
I've got 2 more questions, Chair, if that's okay. This is obviously not a new problem. I understand why in October you're given more resources. You probably asked for them, given the spotlight on this from August last year. What did you do before that? Like, how? I understand the need for more resources to deal with these complaints. Like, was this not a priority before last year, or like how did you undertake what you're doing now prior to that extra funding, or you just didn't?
No. So firstly, there was a process of working with the RBA to understand so when the prohibition first came, to understand the charging processes and what data would be available. Then there was a scoping of where the practices were of most concern, and there were enforcement actions taken in that initial period. There was such charging occurring in larger companies, included, as I recall, airlines, telecommunications companies, ticketing companies, and actions were taken. As a result of that action, the ACCC's assessment is that the larger businesses understood they could not continue to do so. So there was a change in behaviour. That intervention caused a change in behaviour. Once it then became a question of the small and micro businesses, then there has been elements of outreach. We have a small business team that engage elements of outreach to peak bodies to seek to identify. What this now allows us to do is to do that in a much more effective way, because you do, with small businesses, need to get out and about and to be able to much more broadly engage. And one aspect that we have raised in the submission, this prohibition, so it's not the disclosure point, that sits in the Australian consumer law, that is jurisdiction for the ACCC, and it's a multi-regulator model with the state and territory departments also regulators, and we work, Mr. Greiss and his team work very closely with them. But this excess charging aspect in surcharging is only with the ACCC. So one of the other submissions we are making is it will be more effective to be able to reach more broadly, to also sit that in a multi-regulator model. Will assist.
Okay. Did you ask, just out of question, or did you ask, or did you have a conversation with the former government about more resources in compliance in this matter?
I don't know the answer to that question, actually, because it's before my time.
And I also, I can't recall. We can take that question on notice.
Can you take that on notice? And could, if possible, you share, I guess, within the rules, obviously, your current compliance activities with the committee, if that's okay, and, you know, appropriately redact things if you have to or not, just sort of how many you're taking, the general nature of what they're for and who they are. So one last question. I just back to this blended pricing, I still find it extraordinary that this is how, I think this is a big part of the problem we face today, right? People are much more aware of surcharging because it is well known now that debit is very low cost, but when it's passed on as a blended price, it's a lot higher. And all this is known, it's public. So if I went to a retailer that charged a blended price higher than what I know it costs because of publicly available knowledge, and I put in a complaint, how would you investigate that? Because they're charging me 1.6%. I mean, Commonwealth Bank has a blended price of 1.1%. Some people have a blended price of 2.5% that includes Qantas points to the merchant, right? But I know that a debit card costs me, I'm pretty confident the true cost of a debit transaction is about 1%. So if I put that complaint in, which I may or may not do at the end of this questioning, how would you...
It's like a Joe consumer complaint.
Like, because we're being overcharged.
So let me cover 2 points. Directly, the prohibition is on the merchant charging a price higher than their costs to be able to offer. And if they are being charged by their payment service provider a blended price or a single price, then it may not be higher than their costs. So absolutely understand the point you're making is that if you go up the chain, there will be fewer costs because there aren't credit, etc. elements in the cost, but fewer costs for a debit charge transaction. But so far as the merchant is concerned, that may actually be their cost. More broadly, and these are important questions that will be considered as shown in the issues paper of the Reserve Bank, there are important questions about what the costs are, and there are also costs of accepting cash and increasing costs of cash being able to be available broadly at merchants. And so I'm not trying to say you're not raising an important question. It's a very important question, but there are important factors for you and for other members of the committee and for others in a policy sense. In a time when there is change happening, increasing digital, but still consumers who want to use cash, and whether it is actually appropriate for there to be some support from one set of payment mechanisms to others, which are questions of policy and also commercial questions.
So as the rules stand currently, it's almost carte blanche for these payment providers to bundle in a whole heap of things irrelevant to the cost and pass that on to the merchant. And if they pass that exact amount on, 2.5%, there's no recourse for the consumer.
The bottom line answer is yes, what you've just said is right. What I should, though, caveat is if a payment service provider is being misleading themselves to the merchant about the basis of their charge, we could look at that as misleading and deceptive conduct. If there are elements up the chain where the participants, particularly a credit card scheme or a debit card scheme, are not complying with the regulatory framework the Reserve Bank has in place, in the regulatory question. But if that's being met and there is proper disclosure happening, then the answer is yes to what you said, to your question.
Bit of work to do there. Thank you. Appreciate your evidence.
Thanks, Mr. Laxale. Well, look, I've just got a few additional questions. So just going back to mergers, so you talked about the fact that I think the Commission is going to be looking at Blade and other data to better understand industry concentration, but also to better understand the impacts of individual proposed mergers. One of the themes that came through in our competition inquiry is that some suggested, so some people outside of government, researchers and consultants and others suggested that there would be merit in government, both through agencies, regulators, departments, having having access to better quality data and more granular data to inform both policy but also some of the decisions that you undertake, for example. So just wondering if you could step us through, what your better data set is going to look like, how it's going to be more functional than perhaps what's been used in the past.
Thank you. So we are currently working through our specifications for it, but these are the broad areas, and it's possible Mr. Leuner will want to also add points. We will be collecting firstly the data that is relevant to thresholds, so revenue over the period. Then we will also be collecting the data that is relevant to the position of those parties in the market. So sales revenue, capacity size, number of units sold. As best as we can, we will also be gathering that for the relevant markets as well. And we will be seeing change over time in addition. And we also will be gathering what is the consideration for the transaction. So we will have a much better picture of the size of the transaction, its impact, looking at the elements of market share, the data pertaining to market share, and depending upon the nature of the product or service, much more detail about the manner in which it's supplied and data concerning that, including some of these questions previously have been looking at, are there differences in pricing in certain areas, in regional areas, local areas, national, for example. Where that bears upon question of the relevant market definition, we will also be getting that data. So it'll be a much richer source. We are working on a basis that we would provide data on notified mergers to the ABS to link into Blade so that it would become generally available. So we are looking at the design of the database with that interaction included. There are other ways in which we are seeking to get broader access to data for other parts of our work apart from mergers, including enforcement. And we have been doing analysis both to seek to identify sectors where there may be, we try to filter to assess whether there may be cartel behaviour, looking at movements, particularly in prices and questions of concentration. Are there factors that would say to us we should look more closely? We call them sort of short industry profiles to look where we should target. And we are looking to enter into agreements to obtain data. We have entered our first one with the South Australian government to obtain government procurement data to be able to look at the pricing proposals that are put to government. So we are partway through a process of a significant data transformation. It was one of the recommendations of the committee that we should be doing so. And we are looking to apply that in our enforcement as well as our mergers area. And we have big initiatives underway in scams, of course, also to set up both the technological links but also the capacity to share actionable scams intelligence.
So I think that all makes sense. I mean, obviously that more granular data will help inform analysis of thresholds, but there's also a broader question that we touched on in our inquiry, which is how industry concentration and industry structure affects consumer outcomes, affects productivity, affects market dynamism. And what was interesting in our inquiry for me was that there's not unanimity on that, and that's healthy thing, I think, because these are big, complex questions. But across government agencies, there wasn't unanimity on whether concentration was a problem per se. But I imagine more granular data will help to inform that ongoing debate and discussion and analysis.
Well, we absolutely agree, and the process, that the project that we are working on in a cooperative way with Treasury, seeking to use Blade and PLIDA in order to, first off, just in a sort of preliminary trial basis, to see whether using the data we can identify sectors and then even local areas which have appear to have higher concentration than others. But once we have an ability to map in that way using the data, we can then ask ourselves, can we see other behaviour bearing upon the quality of and the vigour or not of competition mapping to that analysis? But without first having the data and doing the analysis, we're not able to be as well informed, exactly in the way you're referring to, Chair.
So another aspect of this is the procedural aspect. I'm just wondering where things are at in terms of, for example, information requirements. So we're moving towards a system where there will be more of an obligation to notify the ACCC. Some have asked questions about how much information should be presented and when, and how much red tape obligation that will create. I mean, our committee recommended that we should move towards more of an obligation to pre-notify, and that would be more in line with international best practice. But just interested in where some of the thinking is in terms of the balance with not being overly onerous, but also interested in your thinking in terms of where the ACCC's own obligations or commitments might be in terms of its own speed of decision making.
So they're very important questions, and they're ones that we want to give you, the business community and the broader community, confidence in, and which is that we will calibrate the information requirement to the likely risk. And in that, we consider it would be preferable to have a short form for the majority of less likely to be of concern transactions, and a longer form with more required information to start the process for those which present as more likely to raise competition questions. In addition, we are very focused that at each stage of the decision making, that same level of question of what information engagement is required is calibrated to the level of risk, and that the time frames. One of the aspects everyone can be very certain of is that they are strict timeframes, and if we fail to make a decision in time, it's a deemed approval. So we must keep to the timeframes. The BCA did raise a question because there is a capacity, but there are guardrails for it, a capacity for extension where we issue a mandatory information request where we have not received the information that we require, and that would be in a complex matter. Or if we can't determine, is it a complex matter? And there can be an extension, but it is limited. We have undertaken and will be reporting when we do use our mandatory information gathering powers, and there are consequent extensions, so that it's quite transparent what is occurring. We'll also see if Mr. Leuner would like to add material here.
The only additional point is just that there should be a waiver process as well, so we can grant a notification waiver, which will be an even easier process than a fast track phase one decided in 15 to 20 business days, likely with less information required and less sort of regulatory burden for the parties.
And you talked about two reviews, the 1 year review and the 3 year review. So can you just set out exactly what's going to be covered in each of those reviews?
Yes. The 1 year review is looking at whether the thresholds that have been set are delivering the intended protection. So there are a couple of possibilities there. One is that they're set too high and there are transactions that should have been caught that weren't. But the other is that they're set too low and we are receiving too many transactions being notified. The 3 year one will look at all elements of the regime, which is quite a rapid review. So it will be broad, evaluating whether the reform is delivering the policy objectives for which it's been put in place.
And that would include broader economic impacts, including dynamism, competition within certain sectors and so forth?
Yes.
Yeah. Okay. No, thank you. So I had a question in relation to penalties for serious misconduct. So penalties this term have been strengthened for serious misconduct. I was just wondering if there's any analysis by the ACCC around what the impacts of that have been based upon instances where they might have come into play.
So those penalties will apply for conduct after the date that the increase became effective, which I think was November last year. However,
was that too early to tell, probably?
In part, but I think our experience does confirm, and it is why the ACCC has been a strong advocate for higher penalties, because it is very clear in the ACCC's experience that, which was why we really welcomed that change, that if penalties are at a level that is just seen as a cost of doing business by a larger company, the company does not have a financial incentive to comply. And we have certainly, for example, seen that after the $100 million penalty that the court imposed on Qantas plus the 20 million consumer remediation, that there has been just much more attention given by larger businesses and questions raised about approach, etc. So we can see it is definitively important in the incentives that are set up to be compliant.
Mm-hmm. No, thank you for that. And this will be something we'll follow up on, I'm sure, after the election, whenever it is. I just wanted to ask a couple of questions about standard definitions in insurance. This is a piece of work that's been going on for some time now, I think, between the ACCC and the ICA. It also came up, as you know, in our inquiry into the insurers' response to the 2022 floods. I'm just wondering, firstly, where that's up to.
So we did participate in an internal Treasury consideration of it, and also in the and we put submissions forward relating to the question of differences in definition and the capacity and value for it to be standardised. I will see whether Ms. Ross has any information about more up to date. I had participated in committees discussing those questions on the definitions and the submissions we were putting in, but I do not know the precise answer to the question about what stage it is now at.
I'm aware those discussions and submissions have been made, chairs. I think I will have to take that one on notice.
Okay. And look, I just wanted to put a proposition to you, like my personal take, but also I think it reflects where the committee landed in our inquiry. And just interested in your response to it. I mean, my personal take, and again, I think this is reflected in the committee's analysis and our recommendations, is that it's useful in a market to have a variety of offerings that benefits consumers, whether it be products or whether it be services. And so it's useful if each insurer in this context offers a range of different products, but also if across all insurers, there's a wide range of different insurance policies. There is a question mark over whether the proliferation of too many different services becomes difficult for consumers to digest and comprehend. But leaving even that issue to one side, it does seem to me that with different insurance products, having different scope, having different exclusions, that's one thing. But having the same term defined in different ways, that appears to be a level of differentiation which almost no consumers would be able to comprehend. Now, it's quite a step to then say that the industry with the regulator should then standardise. So I'm not suggesting that level of potential confusion should necessarily lead to standardising a whole raft of terms. But look, my sense, based on the evidence we received, is that standardising flood had been useful and had reduced the number of disputes after floods. It does seem to me to be an area where one could usefully standardise a few terms while maintaining the possibility of product differentiation. And it just seems to me that product differentiation is useful, but it doesn't appear to me to be particularly useful for consumers to have, in these kinds of products, terms defined in slightly nuanced ways that are different. That just seems to me to be not very useful, and in fact, very confusing, and it makes the likelihood of disputes greater, and in fact makes AFCA's job a great deal harder. So that's a set of propositions from me. I'm just interested in your thoughts on some of the trade-offs here.
So this is one of the examples where I think the ACCC's interlinking responsibility for both promotion of competition and protection of consumers is very valuable. Because this is a question of allowing absolute differentiation and diversity and different responses to needs, but weighed up against confusion in frankly, pretty complex areas, actually, and the difficulty then for consumers to make decisions about what they're being offered, let alone to compare what they're being offered.
Yeah.
And you don't get the benefit. We also quite clearly can see that if consumers can't make well-informed, reliable comparisons, you don't actually get the ability for competition to work on the merits and understanding that intersection, all of which would say that our analysis would support the propositions that you were just referring to. We are also very aware, and we are seeing this in our insurance price monitoring, that while the pool is beginning to deliver some premium relief for some consumers in some regions, and it is having, one of the areas that we are seeing most importantly is that there is more potential for insurers to use the pool to motivate private risk mitigation. And whereas in our first report, we did not yet see insurers focused on that, we now are seeing a number of insurers focused on it. And there is actually some differentiation and competition between them. As to there are different examples of that. So really where I'm taking this is in a situation where there are some valuable steps that we can see coming from that government intervention, which is early impacts. It's early times still because the majority have only just been in the past year of the insurers. We still found premiums remain very high for many consumers in Northern Australia and generally rising around the country. And in that context, it is even more important that the benefit of standardised definitions to enable choice, well-informed choice, because the affordability is a real problem.
No, thanks. This will be an ongoing discussion, and look, in my view, there are trade-offs here. So we want differentiation, but look, product definition or definitions of terms seems to me to be one of the less useful areas. But there are other areas, I think, where it's going to be very useful for this committee to engage with the ACCC, probably after a little bit more time has passed. For example, coming out of our 2022 inquiry, there's going to be a raft of code changes, and there could also be consideration of, for example, mechanisms to provide more transparency on bills. There could be mechanisms potentially where insurers potentially voluntarily might engage in mechanisms whereby they might have more transparent reductions in premiums if there is demonstration of household level mitigation. So there's a whole raft of things I think that are coming through the pipeline. So I can imagine that at our next engagement there might be more detail there to follow up on. But was there anything in that insurance space that you wanted to put on the record?
I think the only other aspects is reinsurance markets are global and they are hardening because of climate change and impact in multiple sectors. So the pool can address in part, but the insurers draw attention, yes, they reduce costs, but in other areas they are facing higher costs because of what's happening in global markets. So it is just an important other factor to be conscious of.
Chair, if I might just add, I've just had some additional information from staff. So I would note that our Northern Australia insurance inquiry did make recommendations around the standardisation of definitions of key terms.
Okay, and that was to standardise some?
That's correct, of prescribed events, so action of the sea, impacts and storm.
Yeah, great. I mean, I think this will be a work in progress. I think we recommended also some work on standardising terms in relation to fair wear and tear and maintenance, which proved to be a very confusing area. But it's not even just the definition of the term. It's also, I think, the way the exclusion works. But again, I think that's going to be another area where we'll probably discuss the right regulatory settings going forward. But thanks for that clarification. Well, just to finish up, I just had a couple of questions around the food and grocery code. So the ACCC is preparing stakeholder education and materials to raise awareness of the strengthened code. I'm just interested in if you could please step me through how that's going to work and what some of the benefits might be of greater awareness, for example, on the part of suppliers of the changes in the code.
And we are similarly looking at these aspects in relation to the unit pricing code as well. But starting with the food and grocery code, one of the aspects which we did identify in our interim report in the supermarket inquiry is, and as your question it indicates, you are very well aware that many suppliers report facing significant information asymmetries in negotiation and then in the way in which price is translated and implemented under their contracts, and also significant bargaining imbalance. The changes in the code in it becoming mandatory, and other key changes are important to assist to address these questions. We have found in our engagement through both more broadly, both in terms of the code, but also in terms of horticulture code and other aspects where we engage with the farming community and suppliers, that there is both a lack of knowledge at times of the way in which the current code and structures can benefit them, and also some lack of confidence in the outcome where they raise a concern. So the purpose of the guidance and engagement is both to increase their knowledge, but also to increase their confidence about the processes we will have underway.
Another area, a related area where there's awareness work being undertaken is shrinkflation, I think, where the ACCC was recently funded to undertake an awareness campaign. What does that look like?
So it is interesting. We certainly do get a range of consumer contacts and complaints relating to shrinkflation. So there is observation of it. One important aspect there is that if the unit pricing code operates effectively, it will identify actually what is that in effect the prices increased per the relevant unit, and all the issues that have been raised about illegibility, small font, not in a position where it can be seen, or even absence, and the changes that came with the legislative change towards the conclusion of the last parliamentary period, that those will also be important as well in the unit pricing code. But that will be an engagement, including with shrinkflation, that will be at a consumer level in order to link for consumers to understand what the tools are that they should have in a range of retailers do have at their disposal, so that they are aware of it, and more reliably, if they aren't able or confused or actually consider that there is misleading claims being made, that they'll be better able to report them.
I mean, I personally probably could do with some portion control on some of the things I eat, but of course one wants the price to drop when that happens unilaterally from the supplier. But I'm just wondering, so in terms of what's happening, there are obligations. What are the obligations on supermarkets at the minute to report unit prices by unit at the shelf?
They are obliged to it. Supermarkets of a certain size, and it is supposed to be legible and able to be seen.
I mean, I see it at the supermarket when I go, but so that's an obligation on supermarkets above a certain size, and it's across almost all products by the looks of it.
Correct. What consumer peak bodies have said to the ACCC is that in a range of cases, the way in which it's implemented doesn't deliver it. That it's confused, that it doesn't have the elements that it should have, that it's not in a position where consumers can see it. And so there is certainly a value in the increase in penalties that came with the legislative amendment last year, but a greater focus for the supermarkets in compliance because one of the aspects, as we commented on in the interim report, many more consumers reported doing price comparison before going to do their shop. And it is...
So how's that being reported?
So we reported that in our interim report.
So that was something you recorded in your study of consumer behaviour?
Yes.
Yeah.
And so, which is very strongly part of consumers being more price sensitive and having constraints on their household budgets. So they, through online methods and other methods, are even for a weekly shop doing price comparisons, many reporting before they choose where to make the purchase. And that means that these aspects about better disclosure so that they can make an effective, it's telling us these price comparisons are even more important than ever before.
No, that's good to hear. And so that's indicating that at the actual point of the supermarket, obviously people sometimes choose based on brand. At a time like this, they're choosing more based on price, and we know that some people are shifting to lower priced brands or products. But I suppose the interesting point in this particular context is if there are two boxes of the same size, but the unit pricing tag says, well, one of these boxes has half the product in it compared to the other one, that is now something that consumers are noting and it's factoring into their decisions.
Yes, and certainly from consumer peak bodies, they were emphasising this makes the effectiveness of the unit pricing code even more important.
Yeah. Okay. No, thank you for that. Well, again, this will be one of those items of your work that I think will be good to follow up on down the track. I think it's very important also just in terms of holding suppliers to account.
Yes, we absolutely agree.
That's all I had. Are there any other issues that you would like to flag before we finish up?
Perhaps, yeah, I'll do it quickly. So this is very much at a high level, and I apologise for that, but I just did want to point to it. When we think about key in regulatory settings that have a prospect to put more accountability, more capacity for there to be more vigorous competition after mergers, which we did rate number one, and we think that merger reform is incredibly significant. But the next we do think is digital platforms reform.
Yeah.
Because in a context where so much of the transactions across our economy are now occurring digitally, including with a payment in an app store, through mobile payment, one of the platform's own payment process. But in addition, where it is almost inevitable that Australian businesses are using search, online advertising in conjunction with social media services to identify customers, to make connections and then to transact. We do consider that the consultation which Treasury is doing on a targeted platform, only critical platform-specific, service-specific regulatory framework is very important, because it is the enabler of so much of Australian economic activity sitting with areas that the ACCC has identified because of the strengths of a small number of those global platforms that sets up arrangements that impede contestability. So that's number one. The second one is unfair trading practices, which is also going through a consultation process supported at a Commonwealth. And the reason we identify that is unfair trading practices between a large business and a small business undermine the ability of the small business to compete with a large business or to compete with larger businesses at other levels of the supply chain. And, of course, also impede consumers being able to make decisions on their merits or, in fact, having even made a decision to cancel because they want to churn and switch to another provider, that they have to pay a high. It sets up, you're very well aware of this, Chair, you made a range of recommendations relating to that. But so that's the second. And then the third, and we put some submissions into the National Competition Policy Review. We are concerned about the questions of in access, but particularly in relation to monopolies where they monopoly price. So, and we're not suggesting this is a simple area to resolve, but where there are key monopolies in areas of Australian infrastructure, those are elements that we do think when there is sufficient time, and it's a possibility under the National Competition Policy reframed and new agreement that's been entered into to look at that question.
No, thanks for those three issues. And no, access and monopoly pricing aren't simple, but probably none of the issues today are simple, which is why they're raised in this forum. Just on the digital set of issues, and look, that wasn't raised today, but look, I think the whole committee would consider it to be a very important set of ongoing issues. It obviously featured in our competition and economic dynamism inquiry, and we referenced your work extensively in our analysis and recommendations there. I totally agree with you. It is already ubiquitous, but its tentacles are, if anything, spreading further into our economy and life. It's an area where there is, as you say, already market concentration in a lot of areas and vertical integration. And I think when we looked at this, and I think this is the way that your inquiry has looked at it, is it's almost like a set of globally impactful ecosystems which are just growing in their influence. I mean, one thing that has struck me in this area is not just the complexity of all the market concentration issues, and this came to me in very stark ways on the social media inquiry, which I was a member of, but it's also the particular challenges of enforcement in this area, whether it be regulators or even lawmakers. And this seems to be, I mean, multinationals operate in our economy in a range of areas, but this seems to me to be one where there's particular challenges in meaningfully enforcing whatever it is we might end up deciding is the right set of regulatory settings.
We agree and understand. One of the reasons we had proposed the designation specific code and service model is the ability for Australia to learn from and put in place regulation that's coherent with other jurisdictions like the UK, Europe, India, Brazil, a number are moving, so that we gain a scale on a regulatory intervention sense with other jurisdictions. It means that Australia is not doing this alone as a medium-sized economy in the world, the 13th. So we're a significant economy, but we're talking about very large global companies. And we very carefully thought about the framing of that recommendation so that we could be flexible, adapt, apply a model that is consistent with overseas models in the areas which are important for the Australian economy and modified to reflect that, but that we are not, in effect, expecting a very large global business with global technological and commercial infrastructure to say this is a modification that this market just doesn't warrant from our perspective. So we do a lot of work working with other agencies globally to understand what they're doing and what they're working on. And we think this is a path for the best success to have a regulatory framework that is coherent in engagement with the platforms, but in addition has real prospects of actually changing behaviour and being able to be enforced.
No, it's an interesting frame, and I think it's fair to say that when it comes to multinational taxation, broadly speaking, there's a similar approach of everybody moving together as much as possible.
And yes.
But thank you. I'm sorry.
We need to achieve regulatory scale in the way they seek to achieve scale.
Yes. Well, thank you very much, Chair, for your evidence today. I think there's a raft of issues like mergers and anti-competitive conduct at the economy-wide level, but also a lot of sectoral issues, whether it be petrol pricing or surcharges or insurance that I'm sure we'll follow up on next term. Can I just thank you as chair, but also all of your senior leadership team for their high level of engagement throughout this term with our competition and economic dynamism inquiry in particular, but also in terms of the regular interactions as part of the oversight of the annual reports. I think it's been a very productive term, so thank you for that. And I look forward to seeing you again soon.
Yeah, we thank you, Chair, and all members of the committee, and that's on behalf of the whole team, because we have found it stimulating and very important engagement, reflecting a shared real concern with this committee about making changes that will address the issues that you have identified.
Thank you. Well, the committee secretariat will be in touch with you in relation to any matters arising out of today's hearing. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to any transcription errors. I now declare this public hearing closed.